everyone. Good evening and welcome to the short-term rental task group meeting on March 2nd. Thank y'all for being here again. I think we're making progress in our efforts to just do some collaborative adjustments to our mostly enforcement is, I think, mostly what we've ended up talking about. So I want to start, as we always have, with going around the table and doing introductions, just so we remember who we all are and what we represent, and then we'll get down to business. So Elise, let's start with you.
I'm Elise Renzino. I've been on the board of NASTRA for the past 5 years. I've recently rolled off, so no official capacity there at the moment, just a member and an owner-occupied host.
Gotcha.
John Dotson, Parks Realty and Greater Nashville Realtors.
George Rowe, I'm the principal broker of Compass and the chair of the Greater Nashville Realtors Legislative Committee.
Bonnell McBroom, STRP Chief, Metro Codes Department.
And I'm Berkeley Island Metro Council member at large.
And I'm Joey Hargis, the Metro Zoning Administrator.
Britt DePriest, Historic Germantown Neighborhood Association and Compass Real Estate.
Great, thank y'all for being here. We have other members who I hope are just stuck in traffic and will be here shortly, but if y'all don't mind, I'm going to go ahead and start because I've got family in town and I want us to end on time, so doubly motivated. So quick introductions. So just a quick review of last week's meeting. We worked through kind of some potential legislation that Mr. Hargis had written dealing with owner occupation and enforcement, and looked at the notification, which we're going to look at revisions of that Mr. McBroom has prepared for us. And then talked about some legislation that is on hold in the council, sort of waiting for us to do our work. So hopefully we can come up with some solutions that will satisfy the council members that are trying to solve some issues there. So that's what we did last week, and then we all left with the homework of looking over some of those items. And if you had the opportunity to go back and speak with your community groups, I would welcome feedback from that, and we'll become more deliberate about that as we get closer to having honest to goodness legislation to show people. So any other comments about the notes of last month's meeting or the summary thereof? If not, then I'm gonna go to codes, Mr. McBroom and Mr. Hargis, and see if there are items y'all want to bring up. You've provided us with the updated documentation that we can talk about at this point.
Yes, I have the.
Oops, I hit your mic.
Sorry, I have the owner-occupied and not owner-occupied short-term rental neighbor notification templates. We've made all the corrections that were requested at the last meeting. One that is not noted on these is that the wording will not be considered has been changed to cannot be considered, and that was taken care of. That is in the final template.
Okay, thank you.
Basically, we have added the phone number and email address of the owner, regardless of whether there's a contact and if that is a different individual. But both phone numbers will be listed on the notification. And also we have added the wording, I intend to follow all regulations, ensure that my tenants comply with all requirements. And then also, please send your comments for the zoning administrator's consideration to strpquestions@nashville.gov. And then the stipulations on when that is to be submitted. We had to put that in because otherwise it would slow the permitting process to a virtual crawl. And I have 3 people that work very diligently on the issuance of these permits, and there are a large number that they process each month. They do a very good job. So in consideration of that process, we needed to add that wording.
Great, we want to keep it flowing. Yeah, so what we simply said is if they take more than 10 days, then it won't be part of that. Now, I know at the last meeting, we talked some about putting in specific language, listing some of the most key regulations, and I see that is not here, although there are links to the Metro website, and I have not memorized the website yet. So if they go to http://strp.nashville.gov,
Yes.
does that get you to how to become an owner? Is that kind of the first thing you see, or would that be a good landing spot for someone who was interested in knowing what the?
The first thing that should pop up for you will be STRP permit applications. We have the legislative history, which spells out the current ordinance in effect, and then ordinances that have that govern grandfathered permits. It's a simple link system. You go to the appropriate ordinance, you click on the link, and it pulls up the ordinance for you. Now, unfortunately, today we had a brief interruption. We had 4 of the ordinance links that were not operating. However, they're aware of that, and it should be a very quick fix. But in any event, it's in that location, and then if you just go and type STRP in the Nashville.gov website, it will come up, short-term rental property applications. And then at the bottom of that page is related tabs. If you click on that, it will also get you to a separate page that lists the same thing, the same legislative history with all of the ordinances, and also giving emphasis to the current ordinance that is in effect.
Gotcha. Do you think, I just, in the spirit of what Ms. Roncino was, I think, asking us to do, do we, I mean, I know this is a hard question. It would be hard to have a simple kind of one page or one screen, shot that sort of said, here are the key things, my permit gives me a maximum number of people. I'm not supposed to be having noise that's audible beyond the property line, but actually that is only amplified noise that's sadly, if it's just happy voices, that's not necessarily, but is there currently a place where those things are sort of summarized? And I know that we're in a bind sort of because it's different for every kind of.
Yeah, that's the complicating factor. First off, there's owner-occupied and not owner-occupied permits. Each have different applications and are governed by different portions of the ordinance. In addition to that, there are grandfathered permits, and so each of those has a different governing ordinance. So it's very difficult to make it applicable, one basic cheat sheet type arrangement whereby you can do everything. It's just not really workable. But we have pulled together the common elements that apply to virtually all permits. And we have a most frequently asked questions section, and also a section, and I can't recall the label of it right now, but it's governing ordinance. And it pretty much is things that are applicable to all the different governing ordinances. Doesn't by any means cover everything because there's so many different categories.
Right, I understand that.
And we added to the affidavit that the owner-occupied affidavit, because it will only apply to permits going forward.
Right.
Well, from the last ordinance that was passed where the whole or entire house could not be advertised. But we now have it in the affidavit that says, I'm applying for an owner-occupied permit, and I certify that the subject property is my permanent residence. I certify that I will not advertise the whole/entire house on the website platform. I certify that this STRP will maintain total compliance with the Metropolitan, Nashville, and Davidson County STRP ordinance in effect at the time the permit was issued.
And this is the application
This is-
affidavit for
That's correct.
the first application or for renewal every year?
That's for the first application.
This is an application affidavit. Okay,
Yes.
that makes good sense.
We have not finalized the notification of the requirement that they're going to have to resubmit their documentation anew each year as if they were applying for a permit, which they previously had not done. But we can do it administratively. But we first have to have that notification on the website. Subsequent to that, then we will adjust the affidavit for renewal to fit.
Gotcha, that's great. Okay, well, I appreciate the work you've done on that. I think the one thing we could do to be responsive to the request of Ms. Roncino is, if that FAQ is something that you see as soon as you go to the website, then that's probably great. I just know sometimes when I've been poking around, I keep finding stuff on how to get a permit when what I want to find out is there's this guy next to me and I want to know what he can and can't do. I just need to learn more about that. And it sounds like that FAQ link is exactly where we want to be, that would spell out most of those things. Is that something that's, or would we perhaps want to direct people to that as opposed to just the how to get a permit page?
Unfortunately, we had it that way, but with the web page complete redesign, there are now multiple ways that you can.
Right, get at things.
That's right. And so what used to be the page that would come up first would be that, but now what is most obvious to you is applying for a permit.
Gotcha.
I mean, that's the first thing that pops up everywhere you go. And that page is rather crowded. But at the bottom of that page is related topics tab. And if you click on that, that will take you to the question and answer page.
Gotcha. So we may, and here's first homework then is, I would ask everybody to go to the website, and if there's a link that's not too long that could be put in the letter that would land you at that place, as opposed to the how to get a permit thing.
And Berkeley, if
Or, I
could-
mean, I will say, IT has been really nice, down at that bottom where it says, has this page been helpful? And I always say, no, here's what you need to do, and they very cheerfully fix things for me. So we may be able to put in a request to do that.
I think the way that they've addressed it is really about as simple as it's going to be, because
Gotcha.
what they have is, the first thing that pops up is applying for a permit, and it's a very all-encompassing page.
Mm-hmm.
It goes a little beyond just the application process. It gives you some additional information for people who are not applying, just general information. But then at the bottom is the tab that if you don't find what satisfies you there, you click on that and it's going to take you to it.
The FAQ, okay. All right, well, I think we just want to, let's all practice, and if we feel like that's good enough, then maybe we're done.
And I've got to tell you, the website is a work in progress, and it changes.
It's a living,
And
breathing document.
after this legislation, however it may come to fruition, passes, it will mean more changes.
Right.
So it's never going to be the same.
That's a very good point. Oh,
in Berkeley,
Yeah.
to that point, we've asked ITS to update the legislative history to put dates on it. So if you've looked up the neighbor's permit was issued on a certain date, you go to that link, and those are the rules governing that permit. The website that Max listed on here has a link that says rules for operating STRP, and that's what Max talking about, the general rules that apply to everybody. But if you want-
okay, and you can see
and
those.
it's, yeah, there's a link right on that page that's on
Gotcha.
this notice. But the one Mac's talking about, and we've asked IT, is to give us dates. So like this ordinance was enacted on this date, and the following ordinance was enacted on another date. So you know if their permit was issued between those two dates, this is
That's what you listen to.
this is the ordinance that governs their particular use.
Gotcha, great. Well, thank you for that work on that. We appreciate you incorporating stuff and getting that approved. I know that was an extra step for you, and we appreciate it. Did anybody get an opportunity to talk to community groups and any feedback from those? Mr. Dotson, you're nodding yes. You want to tell us about that?
Which part?
Let's start with the good part. Let's do the happy part first.
We're very happy that there were short-term rentals in Nashville.
They serve a purpose.
The amount of money that they're contributing, both in terms of tax revenue and ancillary income, is amazing. So is there a specific part of
I
this?
did not know if you had the opportunity to say, here's legislation we're considering. Does this group feel like that's good, or do you have suggestions on how to make it function better?
I would say the one that we had the most opportunity to talk about, we talked about parking, we talked about the noise, and we talked a little bit about the potential to exempt certain properties that are in NS zonings.
Right.
We'll start with that one. That's
Gotcha.
anything that creates more of an opportunity for there to be a short-term rental. In general, we're going to be supportive of. We felt like it was important for us to say we were adamantly opposed to the NS zoning, and particularly in the way that it was described at the time it was rolled out versus how it's been applied, night and day. And in general, I don't think you're going to find many realtors that are enthusiastic about highly restrictive overlays. They have the net effect of reducing property value,
Right.
making things harder to sell. And then
Well,
again,
as you know, this overlay would be a undo the NS for one lot, which I think that's the discussion we'll have in just a minute. Is that really the best tool, or is there another way to do that?
but we'd like to see the whole thing roll back, but
Gotcha.
anything that makes it more possible for there to be, somebody to have that property right, we're in support of that.
Gotcha. Good deal. Okay, thank you for that. Any other community feedback?
The feedback that I received was mostly about the parking and people being very concerned about that, which I think was evident with the people that turned out for the public hearing, and as opposed to the people who turned out in favor of it, which was, I think, one person. So in general, I think that's the big concern that I'm hearing. And as far as just neighborhood, anecdotally, I'm in District 6, so there are some areas that are congested with parking already, but no one seemed to credit it to short-term rentals in our district in East Nashville.
Thank you. That's good feedback. And we'll take that into consideration when we officially get down to that. So let's see.
We had a little, if you don't mind,
Yes,
we had
go
a
for it,
meeting
Rick.
also in Germantown. And the overlay that we talked about, the people in Germantown don't have any problem with owner-occupied short-term rentals. And I don't know if it would make it easier, but they would be in favor of letting NS have owner-occupied short-term rentals. It's the non-owner occupied that give people heartburn that we talk to. So I don't know if that would make that easier or not. It would be changing a whole zoning classification, so it's probably not an easy task.
Yeah, that's a big one.
But if the overlays were used in such a way to say, hey, this is zoned NS, but it's an owner occupied overlay, they would be all in favor of that.
Okay.
Yeah.
Britt, was there any concern, since we kind of have gotten down to one of the major issues is the illegal owner occupied and not so much the non-owner occupied? Is that a concern for people that they're going to just do it illegally?
I think it's probably a concern. It's not really one that was expressed just because in things like this, we kind of feel like, what can we do about it? But that's not been a major point of concern that we've heard.
Gotcha.
But we had some ideas about parking and distance requirements and all that. I don't know if we want to get into that now or if we want to get into that later.
Officially, it's on the agenda in a minute. So
Okay.
let's, just acknowledge that those are the issues that y'all were talking about, which is helpful, and
Okay.
we'll get to it more particularly as we get to that. So,
Berkeley, one concern on the
Yes.
NS overlay from my standpoint, if you're going to go through the rezoning process to put an overlay, it would be far easier, I think, both for codes administration and realtor community and development, owners to know, it would just be just as easy to repeal the NS off that parcel. If that's the intent, to allow them to do NS. You're going through the exact same legislative process anyway, just repeal the NS off that lot or lots you want to allow short-term rental. That would be far easier from a standpoint of, I think, everybody, rather than, your base zoning says no short-term rental and then, except this. You're sort of undoing it with an overlay. It just seems makes more sense to just repeal
and it's
if you-
it's
equally
the same
spot zoning,
exact
yeah.
process
Okay.
that you're going through to.
That's a good
And
point.
if you just remove that RS, then you go back to the base zoning, say it's an R8, for example, R8 NS. You just remove that NS, and that's a zoning classification with which people have a greater familiarity.
And they can't get non-owner occupieds anyway, now in our district. So you sort of eliminate the concern of non-owner occupied, new non-owner occupieds coming in.
Non-owner occupied. Right, okay, so we're good on that. Okay, well, that may be a tool we can talk about. So then let's officially get into draft revisions on things that we've been working on, and I'm gonna turn to Mr. Hargis, because he's done many of these already. The owner occupancy and annual documentation. You had passed out a draft a couple of weeks ago, that I don't think that's in the stuff that we've got, but if y'all are creating folders like I am, you've got it. But that had legal language to require 5 pieces of documentation as opposed to the 3 that we require now. And it was sort of 2 out of a somewhat hard to forge category. Although it included your driver's license, and we all know how wonderful that kiosk in the county clerk's office is, where you can go get your new driver's license. And then come right back with a different, different home address. So there you are. So, Mr. Argus, you want
Sure.
to kind of read through the key sections of that, and let's just see if we're good with that.
I failed to bring my own copy of that amendment with me out of all of my documents I brought today. But here, just to sort of summarize, I'm still supportive of requiring more documentation as part of this ordinance. And sort of breaking it into 2 tiers. One, a little bit harder or stronger evidence that I live here, and those lesser ones, like I talked about, bank statements or NES records. But we get into voter registration cards, we get into driver's licenses, those types of things, requiring more of those. From the standpoint of current ordinance, the way it's written now, we can require that annually. The ordinance says currently on renewals that they will sign an affidavit that it complies, and with that affidavit includes all information required under the application requirements. So I think the department chose to go the affidavit route for ease sake, but we can, under existing regulations, go ahead and require that. On
Can
an annual
you,
basis.
I mean, is this going to require them to bring in are they going to have to bring in the plan again and that kind of thing? I mean, or is there a bunch of other stuff that you don't necessarily need to see that you?
No, I think from the standpoint, for the fire marshal's inspection, those are will be done going forward by home inspectors and that sort. So they're gonna have to bring that plan anyway. This would just be, we want fresh documentation that you still live here.
Right. So you can specifically pull that out, and Mr. McBroom said that we don't necessarily need an ordinance to do that. We
No,
can just,
no, we can
on the
do
website, where you explain how to renew.
Correct.
You'll
And
change that.
the current legislation gives us the ability to do that now.
To do that.
So all in my legislation would just be sort of creating a little tiered system and requiring a little bit more documentation.
Gotcha.
On the front end, which would
Okay.
annually, as they renew, we'll ask for that. So
Okay.
nothing new there. The note I had under item B, legislation for Metro Water's authority to curtail services when properties are in violation or contempt. We're working with Metro Legal now, Tara Ladd and the folks there, and the director, Mr. Herbert, he's out this week. They're working on that legislation. That'll be probably a separate bill that runs.
Okay.
In Water's chapter to grant them permission to do so.
Oh, really? But that'll still be a metro,
Yes.
it'll still be an ordinance, okay?
It is. In the legislation we're proposing, we're gonna bring the language from chapter 17 over to chapter 6. That gives me the authority to curtail services. This
Right.
is just a coupling bill to get Water. Water wants some legislation to back up their ability to cut
Gotcha.
that off. So
And we'll just run those at the same
we'll
time?
run those concurrently.
So all these land at the same time?
Yes.
Any comments on those 2 pieces? I mean, I know that we are unfortunately missing, I think, many of our neighborhood groups tonight, so I will speak for them. And I think that's been an issue that they, from their perspective, have more concerns with. So I think there's definitely a will just for that particular type of enforcement to function better. And I think that the requirement to bring those documents in on an annual basis. And we're also giving you the authority to consider other information, like if they have 2 addresses that show up on Metro.
Certainly.
Planning.
From a practical standpoint, since I became zoning administrator, and I think Mac can probably talk to that, we've denied more permits than we have historically over this. The public information we're looking at says, hey, I live in Mount Juliet, and I'm, my tax bill's going to Mount Juliet, everything's going to Mount Juliet, but I'm claiming this location. Then we've denied more permits and provided opportunities for folks to appeal that decision to the short-term rental board.
Gotcha.
Yes,
Okay.
that's correct, because first off, we've had the advent of the short-term rental appeal board, which has been a
Right.
great asset, and rather than make sure that everything was enforced and going through the courts to achieve that, we now have that board, and it's it's functioning very well.
Great, glad we've done that. So we talked about the owner notification template already. Any other comments on that one? We're all gonna check and see if the link gets us to a place where if I were a neighbor and I wanted to know what was going on, and if it doesn't, then we can talk to IT and see if there's a way to, they're great at adding links, so,
There was one thing that I did just go to the link that is in that letter. And one thing I know we've talked about as we've gone through this is making it easier for neighbors of short-term rental properties to find that map that gives them the link to whoever is responsible for, you know, the name that's on the permit application to begin with, that should be living within 25 miles and responsive to an issue. Anything we could do to make that easier to find,
right,
I think would help enormously.
okay. That's an IT question, so, I'll poke around and write them another nice note and see what we can do. Contact info. Okay,
Yeah, I
good
think it would be
suggestion.
a link to the e-permit site on the STRP page is what you're asking for. I would think
E-permit.
IT could get right on that one, yeah.
Yeah, they're great. Okay, good suggestions. Okay, next, the noise detection requirement. Mr. Hargis was not here to have the benefit of the conversation that we had at the last meeting. We talked about legislation that I had thrown out there that just required it carte blanche for all non-owner occupied properties. There was a discussion of whether that was overkill and maybe it was just something that we would require in response to repeated noise complaints. So Mr. Hargis came in and jumped in and said, they're not that expensive, why don't we just ask and put them everywhere? So remind me how that conversation went and how we got to thinking it was better to wait until there was a complaint, and then we'll tune Mr. Hargis back in. Grace?
It's Deborah Volley.
Ah,
It's
sorry.
okay, I just didn't want you to, have me marked down wrong.
Gotcha. You're sitting in the wrong seat.
Yeah, I am usually right there. I think we got around to that because we were saying that, once again, we're penalizing the people who are following the rules. And I tend to think it's pretty easy to get that. So, I mean, that is actually my opinion, but I think when we circled back around, we said, well, why don't we make it be a requirement if someone does have a complaint when they go in to renew, hey, you have a complaint on your property, you're required to have this software now. So I think that's why we landed there, if I'm remembering it correctly.
Yeah, it is. And then George raised a couple of really valid concerns. The first is, how do we verify that it's there? How do we verify it's being monitored? And then what does that do in terms of the requirement for Metro to digest all of that data, track it, enforce it? It just, I
Right.
understand.
Well, it's the manager who's tracking, not Metro. But I mean, I think to your point, it's a much smaller burden on Metro to do anything if we just narrow it down to someone comes in to renew a permit, and do y'all have the information that they've got complaints on there? Because I know we do spell out in there that we allow a grace period if you're in good standing, and we don't allow that if you're not. So I'm guessing y'all check or not?
Yes, we do check for complaints and violations in any open cases or past cases in which compliance was achieved and they were closed. However, there's really no way to enforce this. I mean, we have a staff of 5. We're not going to people's houses. I mean, just understand that's the case, and it's not going to change anytime soon. So it also adds an additional step to my permitting department, because 99% of the applications and renewals now are done exclusively online. We learned with the advent of COVID that this was a system that worked and worked well, and it was much more efficient than come in. We had a system whereby they could set up an appointment prior to 7 o'clock. It opened, I think, at 6 o'clock every morning, and by 7 it was full. And
Right.
it limited the amount of actual permits that could be issued and the number of people that could physically be seen. They issue much more efficiently when they don't have to have a sit down. So, and I say all that to say that I mean, these things cost anywhere from $125 to $145, and the monitoring's a couple extra bucks a month. But right now, as of the last meeting and currently today, you can get any of these units for $39. And, you know, I mean, they're protecting themselves on their advertisements in case there's any type of a price freeze of any type mandated by the government. They have the price at what the price is, but that's not what they're selling them for. It's really very inexpensive. So the best way to ensure that they have that is when they come in for the permit, or when they apply for their permit, they provide the documentation that they have it.
Or an affidavit. Is there, yeah, so I think what I hear is we don't necessarily want to add another step, which I understand, but that possibly there could be a way through the affidavit process at renewal to.
Yes, because the way that the suggested proposal was written, in the event that they have these complaints, or if they have complaints in general, then they're required to come in and have a face-to-face.
Oh, they are?
Yes.
So that's the point where you do it?
Well, no.
No.
I mean, that's what's proposed.
Oh, okay.
But, you know, if face-to-face can be eliminated and it can be done through documentation submitted electronically, that's just
better.
the way to go.
Okay. So again, George,
Yeah.
go ahead.
Are there privacy concerns with this about homes audio being monitored?
I do not believe it, I mean, it's a decibel level.
Okay.
I think there's a, well, at
Yeah, they
least,
don't actively listen. It's just picking up the sound.
And is this
volume
something that
level.
can be just unplugged by the occupants when they're there?
it is, yes.
As popular as noise complaints are, from what we hear, this just, to me, sounds like a step to put people through, and I don't know that it would accomplish a lot, would it? I mean, so let's say that I call the police because my neighbor's having a party at 3 o'clock in the morning on a Tuesday night, and it's super loud, and the police never show up, and nothing's ever done. What has that noise meter accomplished? Are the
Well,
records
the
pulled from the
noise
noise
meter-
meter, or?
The noise meter, hopefully, will have called the manager before I get woken up. And the manager will come to the house, because that's what they're paid to do, and say, did you know that you hit, 90 decibels on the noise meter, you need to tone it down, and I get to sleep. That's what it's supposed to do. And so if, in a perfect world, there is a property that has repeat offenses with noise, then if we can get it so it's between the manager and the tenants, and the neighbor gets to stay out of it and not be the one that has to complain, then that could be great. There were several ifs in that sentence, though, so
Right.
I think that's what we're debating here.
Yeah.
I mean, I think we can all come up with ways that it wouldn't work, but if it works half the time, then that's that many fewer calls that I get from grumpy neighbors asking us why we.
If the occupants know they're going to have a party, aren't they likely to just unplug it? And if so, how effective is this going to be?
I do not know how savvy occupants are, but
Does it alert you if it's unplugged?
I'm not positive
Yeah.
if it does or doesn't.
good question.
So would a way to prove that a noise monitoring system is in effect be to show a monitoring agreement at license renewal? If you have to pay monthly for monitoring a couple of dollars.
Or just sign the affidavit.
You would have to provide, the affidavit, of course, is sworn, and the affidavit also clearly states, pardon my fumbling, clearly states that I understand that knowingly providing false information through an affidavit is considered perjury by the state of Tennessee. I acknowledge that any permit issued based on the false information is subject to revocation. And there'll be similar language on the renewal affidavit as well. But what I would like to see submitted would be the agreement and the bill from where the installation occurred.
And Berkeley, is what you're anticipating here is that the owner of the short-term rental property is going to get, again, if we're going to go with this, that they've had more than one complaint. Now they're required to do this. I've got a follow-up question on that. And they're required to do this, and the monitoring agreement's put in place and the person doing the monitoring is the
Is the manager.
manager. So that doesn't become a Metro issue to monitor. So the manager has the responsibility for monitoring it and logging whatever issues there are, right?
And dealing with them.
So then my follow-up question is, if it turns on, the requirement to have the noise detector turns on more than one complaint, are we anticipating that when that issue is going to come up is when they go to renew their permit?
I
Or would it
believe-
be something that happens during the term of that existing permit?
The way it's written, because I don't work in the office, I just assumed that when it came up, that we would trigger that. I think what I hear Mr. McBroom saying is the easiest way to flag it would be at renewal. So that's not necessarily a burden. I mean, again, it may be a timing issue. I know that the code does require us to notify someone that there's been a complaint within 15 days. So, Mr. McBroom, when we notify someone that there's been a noise complaint, can we include with that? I mean, you know, if nothing else, maybe we include with that a suggestion. Did you know this exists? And you could, you know, reduce your risk of losing your permit if you do this. I mean, we're just trying to reduce the number of incidences, because, you know, people that own a home, just because someone moved in next door or bought the house next door, you know, they shouldn't have to be the ones dealing with it. So if there's a mechanism out there that can do that, and a particular property's been identified as not being responsive to calls from host compliance, is this the next step? That's the question.
If someone does call the police with a noise complaint, is that logged anywhere? That's not registered as a complaint.
Officially, it's supposed to be, but what we've seen in practice is, you know, on the nights when they've got time to come by, they knock on a door, they don't know whether you're a short-term rental or not. They say, your party's loud, you're bothering the neighbors, and if people turn it off, they're done.
But does codes get a record of that?
No.
Okay, so.
If they have to come back again, then they log it. But if I'm the neighbor that got woken up at 3 o'clock in the morning, you know, for the hour it took for them to get there, I'm grumpy.
I've been that neighbor.
Yeah.
I was also grumpy.
Yeah, it's a little bit complicated due to the state law, because basically, if there is a report filed, which Council Member Berkeley stated it correctly, first time they come out, not just short-term rentals, but any property, they're gonna knock, say, okay, shut it down. If they get another call and they have to come back out, then they'll generally write a report. We have access to those reports, and the Police Department Records Division is very helpful in providing those for us. But it really, as we've explained before, in practicality, the three-strike law rule is just unenforceable. I mean, it's too high of a bar to hit, because it requires an arrest, it requires the due process to be fully carried out, and it requires 3 of them in a 12-month period. It just doesn't happen. So, but in any event, in practical application, that was one of the reasons that I addressed with Mr. Herbert and Councilmember Allen about the need with this past January 1st deadline, where the potential for people to be so tempted to obtain fraudulently owner-occupied permits in all these zones, which they're now excluded from, because they're the most time-consuming thing that we do. And so when that time is freed up, then we are able to address these noise complaints in a much, much better way. And what I found from just actually doing it is, and as I've expressed to you before, there are management companies that are responsible, because if they get too many complaints, the owner's going to switch. They lose their money, and their reputation goes downhill. And there's just too much money to be made here in Metro, and they're really conscientious, the majority of them. So when you notify them frequently about a problem property, they generally get on top of it. There have been many of these that install this equipment, but no requirement to do so.
So that's been their response, is just from a business standpoint.
It's because we had the time to continually give them notice, follow up with them, let them know that they're on the radar, and the more of these notices they get, they're more constantly on the radar, and the more we're gonna be watching their properties for
Right.
any other violations whatsoever.
Gotcha.
Because when we have when we have a complaint come in, we check that property for every violation, every time.
That's helpful to know. Okay, well, we probably should move on from this. So options we've talked about are what you have in front of you, which I think is not a good idea, which is just as soon as there's a complaint, there's a response needed from Metro. But if the timing could be worked out at renewal, or if there's an opportunity when they are given a notice of violation, just to talk about the possibility of that and saying, when you renew, that's another piece of documentation we would like to have from you. Does that seem, I mean,
I do like the idea of working that into whatever notification goes out to say, hey, there was a noise complaint made against your property. Here's information on something you can use to avoid that moving forward.
right. We could start with that.
Yeah,
Yeah.
that seems like the simplest next step. And
Yeah.
anyone who is still clueless that this technology exists, that might be the aha moment that they need.
Right. Okay. Good to know. All right, well, I will just say, as someone who hears about it when people are not happy, I'm looking for effective solutions, so this one is important to me. Okay, complaints for multifamily houses. I think what we came up with at the last meeting was that we have, perhaps, we're at the end of it, but there are a number of RM-zoned properties where every single unit is a short-term rental. And the issue has been the difficulty of how does a neighbor complain when you don't know which of the units the issue is coming from? And I think the realtors in the group know that there's always an HOA manager as well, or can we talk about how?
Theoretically.
Okay,
I mean, in any, as far as I know, and George, you can weigh in here, that as far as I know, if you have, even in HPRs, you're supposed to be legally, supposed to be some kind of HOA agreement because you're sharing common area, right?
Right.
And then in these multiple unit structures, there is an HOA, and you have to abide by the HOA regulations, and there's a governance board and all of those things. So it does seem to me that turning first to the HOA, which is going to have, frankly, the best enforcement, because if you violate those rules often enough, they can put a lien against your property. And it's a thing.
gotcha. If the HOA has any kind of rules about
Yeah.
behavior.
I have yet to see an HOA bylaws or CCNRs that don't have something about conduct and
Oh, really?
parking.
Okay.
And those things are just kind of almost standard boilerplate these days.
Okay.
And we're
So-
talking about like in a multi-unit building, right? Like tall, okay, not just a standard HPR, 7 townhomes built together or something like that.
Right.
Yeah, I got to feel there's one that comes to my mind that's on, it's near Centennial Park, and I think it's 17 or 18 units, and it's just turned into a problem party hotel, and that's a nice, quiet neighborhood, so I hear about that a lot. I sold a couple of pieces over there.
So is the HOA not able to deal with that in that situation?
The HOA has not seemed to be very responsive. I'm not sure that their governance is as good as it could be, and, like we've been saying, if you've got 18 units, where's the noise coming from? I mean, there's like 6 stacked on this end, and it's coming from this end of it, and 4 of them have lights on.
But there's an example where the HOA can't manage it, right?
Right.
And, I have clients that do mostly small to mid-sized stuff, 7 townhomes here, 10 there. And those HOAs wouldn't do anything. I mean, if someone had a short-term rental in there, which most of them are written so you can't, but if they did and someone was making noise, I don't know that the HOAs would ever enforce anything.
In those types of complexes, is there also an overall property manager?
Probably not.
No?
Yeah.
Okay.
Yeah, I think you generally hire a professional manager once you get, I don't know, there's not really a rule of thumb, but 15 units, 20 units, something like that, Yeah,
7 or 8 doesn't really, it's not financially viable to hire no,
A manager.
no really good property manager is going to manage that number because it's based on a percentage and there's just not enough revenue.
Yeah. So I don't know, I just don't know how effective an HOA or even a condo association may have a little bit more pull, you know, but I don't know how effective an HOA would be at enforcing anything, really. Yeah.
So what's the solution? All right, you guys are the elected officials and your constituents are calling you. How are you going to fix this problem?
I would make sure host compliance was beefed up, and that if there's a problem at 3 o'clock in the morning, the property managers for those properties would be there at 3 o'clock in the morning to sort it out,
Gotcha.
right?
Yeah, but I would suggest to, and this is obviously on a case-by-case basis, but I would suggest to the HOA is in each one of the units that is short-term rental, that there is kind of like a frequently asked question fact sheet, and it has, here's how you reach the person that owns that unit and causes a problem, and here's where you need to go if there's a noise complaint, and these are kind of like the list of these websites that you can go to get the basic regulations governing where you're staying.
And that would go to who?
I would suggest that be posted in each of the rooms.
Oh, okay.
Each of the units, not the rooms.
Well,
Gotcha.
If it's a townhome situation, right, I mean, it would have to be just posted inside. But if it's a condo building, you could post it in the common area,
Yeah,
you know.
yeah, in the hallway in the elevators and stuff.
Right. It's the neighbor next door that's calling me though. So how do they find out I mean, Britt, what I hear you say is they need to call host compliance. But again, host compliance, you know, all they know is here's this address that has 8 different short-term rental permits.
I think they would all come.
Call every single manager.
I would think.
Let's do that.
I don't know any other way to
Okay.
do it, really, right? I mean, how else would you do it?
Yeah.
And they can get out there and they can stand outside in the hallway and listen and see where the noise is coming from. I guess, I mean,
And
that's what they're
then
being paid for.
They'll be grumpy enough to
Well,
do something about it.
And the property manager is going to get down, like, they're going to figure out what unit is making that noise. Because there's gonna be, if you've got one problem, there likely is 2 or 3 property managers for those 7 or 8 townhomes. They're gonna figure that out pretty quick if you're calling all of them.
All of them. Okay. We'll follow up with host compliance on that one then.
What can a property manager do if they get out there and there's a wild party going on? They can kick them out of the property.
Yeah, they usually knock on the door and,
They follow under hotel rules for a tenant. They don't have, renter rights. They can be kicked out immediately.
I think Airbnb and VRBO's rules about that are pretty clear, that it gives, owning one, I have a lot of latitude if I've got a problem, if I've got to go over and tell them in the middle of the night, pack up and go, I can do that.
got it. Okay, I think that's enough on that one. We have 5 minutes before I join my family. So pending legislation, we talked about the parking requirement. I know that's one that we've expressed a lot of concern about. I think our best response to that is to offer some kind of an alternative or something. I mean, as opposed to just saying we think this is bad. I know you do. But I think we have to acknowledge that there have been some parking problems in some cases. What can we offer as potential solution for those cases?
Better enforcement.
Better enforcement.
You know, you and I've talked about this, and we Greater Nashville Realtors have discussed it roundly, and there's not a parking requirement that we're going to support in any way.
Gotcha.
What sort of enforcement would you be talking about?
Well, as a requirement of getting your permit, that you would have to comply with X number of parking spaces per bedroom or whatever. We're not going to agree to any parking requirement as a condition of a short-term rental
Yeah.
permit.
Currently, what the regulations say today is if you're in a house, you have to have the same number of parking spaces a house has to have. And y'all check that, I'm guessing, as part of the permit.
Yeah.
Yeah, so that's what's in place now. And in fact, what the proposed bill does is instead of saying house, it adds another category that makes it look more like the hotel as we've talked about. So I think that's there is a parking requirement now, and it seems to have worked in many cases, but not in every case. And just just trying to think through what solutions do we have on that. All right, I'm going to leave y'all to think about that one because I think we do have some other pieces that we're close on some good solutions. On the proposed STRP overlay, what I'm hearing is that, at least from a codes standpoint, you see no difference in simply on a lot-by-lot basis.
I would just repeal
rezoning.
the NS off of it. You're going through the rezoning process to put the overlay on, just inverse it, just
Gotcha.
revoke the NS off of it.
Exactly, it's the same process,
Right.
but the end result is, it doesn't have the extra layer, it's much less complicated.
Gotcha.
It's something that, it's a zone district label that people have familiarity with.
Right.
So walk me through that process. What would that look like?
Well, I mean, the current rezoning process is 4 to 5 months going through that process. Go to the planning commission first, get a recommendation, get a council member sponsor to rezone it, to put the overlay over. The discussion I heard was over particular properties, like these properties are okay to do short-term rental, but the council chose earlier to say no short-term rental anywhere. So the easier part would be to just rezone the lots you're okay with short-term rental, take the NS off, and you'd rezone it to whatever it is, MUL-A instead of MUL-A and S. You're still going through the same procedural process, but you're making it clear to everybody, these lots are zoned for short-term rentals, all these other ones are not. Whereas you leave, there's ambiguity of it. Wait, the base zoning says NS, but this overlay says I can do it. There's confusion there, you're creating unnecessarily, I think.
Gotcha. And I think the goal was simply to allow a community input and council process, where if neighbors truly didn't care, there are two different opportunities for a public hearing where people can come and say, we really like this guy and we trust him and we're fine with him doing it, even though we're zoned in S. And that can happen under either the overlay scenario or the rezone to get rid of the NS designation.
So then, let's say George owns a property that's in NS, and he decides, you know what, I want to do an owner-occupied short-term rental. So he goes through the process, right? And then 2 years later, he decides to sell it. Can he sell it where it's eligible for the next owner to get a permit because he's rezoned it?
An owner occupied, yeah.
Oh, well, the permit dies anyway, it's not transferable.
Right.
So if.
But it's eligible for
Yeah,
Would it
if he
be
sells the
eligible for
permit.
another owner-occupied short-term rental?
Yes,
Correct.
because that zone allows an owner-occupied permit.
And that would be true with the overlay as well.
Exactly.
Okay.
So functionally, there's really no difference. It's just,
No difference, just much less
It's
complicated.
just from a zoning sort of, I guess, process across the country, it makes more sense. Overlays are intended to restrict rights on a lot. We're putting architectural designs on an area. Doesn't make sense to go the other direction. You just repeal the base zoning to allow whatever the base zoning would allow.
And people nowadays are becoming, you'd be surprised, more and more savvy as to what zones allow what type of permits and what zones allow no permits. And if they look at this and they see, okay, no short-term rental, but wait, there's an overlay, there's an exception. If they just look at it and it says R8, okay, that's straightforward. And because you'll get people that will call in and say, this place was just issued a permit and it's got an NS on it. Well, it has the overlay. Overlay? What are you talking
well,
about?
yeah. Okay, that one, I think I'm going to have to do some talking to the council member, but I think we have a solution for that one. Proposed state legislation, Mr. Hargis, I think you may have the latest and greatest on that. Can you?
I received a notification right as we started that there was a bill, and I don't know the specifics of the bill at the legislature, I apologize.
I do,
That
it's
was gonna
terrible.
dip into the short-term rental, that apparently it died in committee or didn't come out of committee today, so that may be the end of that for this term, or this session.
So is this the last chance to come out of committee?
I'm not certain.
Yeah,
of the
my
timing.
reading of that state bill was that it sort of reverted everything back to 2015. And I can tell you what the rules were back then, but I mean, I sort of feel like, y'all may look at it differently, we've got 5,000 of these. They are serving a great function just in terms of flexibility and allowing people to see all parts of neighborhoods and spend money in small commercial districts. And those remain, no matter what we do with all our bills and stuff like that. But to have the state take away less and less local control so that we can't adjust as Nashville needs to, which is very different from Sevierville and very different from Knoxville. would be a real mess. So I interrupted you. I think, Deborah, were you gonna say something?
You know what, I was just gonna ask, did we talk about the proposed distance requirement?
No, I skipped that one, so
Okay, I
that one's
just
a little
wanna
more
make sure I didn't
complicated.
miss it.
So let me go back to that one, and again, I need the lawyer to help me out. So this bill was passed, it requires 100 feet from the same kinds of things that beer retail does, from schools and parks and churches and residents and things like that. And it also allows the same waiver process of, all you do, you know, if you come to council and one reading, add a resolution, if no one stands up and says we object, you get the waiver and you can do it anyway. So that passed right about the time that we did another bill that moved all this from one section of the code to the other, and it got left behind. So it's not in the code currently.
But it passed with an amendment, right?
I think the amendment was to allow the waiver.
I thought the amendment was to only require it if the master deed was after September 2020. And that made a big difference for people, because that meant anything built before 2020, you didn't have to worry about this 100-foot rule, essentially.
That could well be.
That-
Regardless,
Basically, so.
They're the expert.
In an event, and one thing is, there were a lot of developments that were already planned, and they were based upon being a short-term rental, and not owner-occupied short-term rental. But in addition to that, existing properties which are zoned that were built 30 years ago, there's still a complication with that as well, because in essence, they're legally non-conforming by way of the waiver.
You're right.
Right.
Metro Legal's told us that ordinance, it's sort of, I think the one bill moved it from chapter 17 to 6, and the next bill says, hey, we're amending chapter 17 to allow this waiver, the distance requirements and waiver. So if the bill had passed in a different sequence, it would have been fine. Metro Legal's told me that separate distance requirement is enforceable. They're going to clean up the legislation to put it in chapter 6 where it should be. It should have codified, but just the sequence of events.
gotcha. And when you say they're gonna clean up, does that,
Metro Legal's going to file the ordinance.
there
to
will be
put
an
it in
ordinance
chapter
filed though.
6. Yes,
So
ma'am.
again, it would make sense for that to happen at the same time
Right.
as all this other stuff.
And we are enforcing the 100-foot provisions now.
Gotcha.
In recent development, just FYI, one of your colleagues had talked about, the language talks about schools and its associated playgrounds. There's an attempt to apply that to colleges and universities.
Right.
I reject that outright.
Can you-
Metro Legal backs me on that. The intent, by adding playgrounds, you're intentionally saying minors, and the goal was to protect those separation distances from schools and playgrounds. And the goal is we're protecting minors from that use, not, TSU
Gotcha.
and Fisk and Vandy. That's never the intent. So-
Gotcha. Okay.
But I can tell you that even though the two bills were passed, that changed from Title 17 to Title 6, and also the noise ordinance waiver were passed on two different dates, they were signed into law on the same day, and that makes it enforceable.
Okay. So, because I know we just passed one, which I thought was interesting, because I'm not sure where it was landing. So that's that. So at this point, legal is planning to reintroduce that one. Meaning from what I've seen, it hasn't come up that often. No one has argued about the waivers yet. I don't know. Is that a hill we need to down, or any thoughts on that one?
Well, we had one this week where, we had a council member that was concerned about a property that it was issued 20 permits, but they had everything in well advance, in advance of September the 1st. So once that was pointed out, I think everything was settled.
Okay.
It's not a common occurrence, no.
Gotcha. And that, I mean, as we get farther out from that, that's not likely to come up again, but that would travel with it as well. I'm guessing, just to be thorough on that one. Okay. So it is encouraging that we think the state is no longer looking over our shoulder trying to undo everything we're doing. So hopefully
At least this term.
this term. And my goal is that, by working through this group and then having some community engagement, that they will feel like Nashville has learned how to do this collaboratively, and we don't need any intervening at the state level. That's my hope. So I think what we've got is that we've written everything we need to write, and that there are some tweaks on the website perhaps. And we may be ready to go on the roadshow and officially take stuff to community groups and get honest feedback and then file something.
My community group's gonna ask awful lot of questions about parking.
And what are we going to say? We think that's not a problem?
That's not what my community group is
So?
gonna say. Yeah, so my
like
community
We
group,
need to talk about that.
yeah, my community group,
Yeah.
when we got together, the reason, the place that the number 4 came from, or 1 per room or whatever.
Yeah.
It's because you look at the parking chart and you think, what is a short-term rental? And short-term rental is not really on there, you know, and the people in that group thought it was most like a hotel. It's probably not that. It's probably not a single-family home, though, either.
And that's currently where the law sends it, is to
That's right.
single-family home.
Yeah, or multifamily, whatever it actually
No,
is.
specifically, yeah.
Oh.
What-
yeah,
Whatever it is.
If it's a multifamily, yeah, right. So the number that we came up with was 1 space for a 1-bedroom, 1.5 for a 2-bedroom, 2 spaces for a 3 or a 4-bedroom, but no reductions. You know, you have the list of ways that you reduce your parking underneath the parking requirements, and none of those apply.
Can you say that again?
Sure, 1 for a 1-bedroom, 1.5 for a 2-bedroom, but rounded down. So if you have 2 2-bedrooms, that's 3 spaces. You know, if you only have 1 2-bedroom, that's 1 space. And then 2 spaces for a 3 or a 4-bedroom.
My only caution to everyone, when you get into that, you're gonna grandfather 5,000 of these. So we're only, I understand the concerns that the current is creating the problem that needs to adjust this ordinance, but this ordinance will have 0 effect on existing permits.
How many more are gonna be permitted over the
Well,
next
that's true.
10 years,
I mean,
though?
yeah, if you, and
If the
that's,
state had his way, another 5,000, but
correct. But for us, just understand that, it's not, there's no retroactivity, we're going back to these problem permits now and saying, hey, give us 3 more spaces, it doesn't happen.
So is there stuff we can do with the language that we have in the current bill to deal with the problems that we're seeing I mean, you know, it's the very dense areas like Germantown and my part of town where we're seeing that.
Clear, and I in no way mean to, diminish the problem, it's there, it's just not gonna be many times we get calls from codes, why aren't you enforcing this law that just passed? Because I can't, they're protected under things. So as long as there's kind of that baseline understanding by the neighborhood groups,
I think that's the biggest concern that I hear when I talk to people, is that this is going to affect all the properties that are being built right now or had pulled permits to be built. And so now, people who have planned on doing one thing and have planned a certain number of parking spaces are left holding the bag.
Sure, I mean, I understand
know.
I understand what it is to develop a site plan for a property and how you have to do that a year before you close on it and 2 years before you start working on it in most cases, so.
And that, sometimes we have dealt with that by
Yeah.
saying this will become effective 6 months from now, just
That's
to
right.
allow people the time to, to get stuff that's in process that was based on one set of rules
That's right.
completed. So that may be one way to do it. And I was just going to go back. I think I gave everybody a copy of the parking table. And it may be that what you're describing is in the parking table, and we just add the language about no reductions? Or
I
is
don't
it
think
different?
that's in there. I think, I don't know anything about this, but it would seem to me the simplest way to do it would be to add a use under the commercial section of non-owner occupied short-term rental and just put
those-
whatever numbers we come up with in there
Yeah,
and not link it to anything.
I
Just make-
still
have it be its own.
think that looking at it on a area by area basis is a better way to go about it than as opposed to apply this across all of Metro. We have, 2.61% of all the complaints are parking, and look, I know you got parking problems in Germantown. I've been over there trying to find a place to park to eat, but,
I would just say that if someone who normally parks on their block and walks to their house has to circle the block 5 times and parks 4 blocks away, the first thing they think when they walk in the door is not, I'm gonna go to host compliance and lodge a complaint. That's just not what they're gonna do,
What was the suggestion that we kind of touched on last time about us, setting aside some of the area for residential parking? I don't know how that would even work, but.
I mean, we have residential permit parking programs where, everyone who lives on a street can, for $10, get a permit that they put on the dash of their car. One of the complications of that is that, the issue frequently comes up at night, and there is no enforcement at night, which is the one other thing I wanted to get to before we disband for the.
You know, Germantown has historically not been in favor of resident-only parking just because half of the people in our neighborhood, maybe more than half, are businesses. And that's where their clients park, is on the street, you know, so we've never.
Yeah, and you
never
need to
been in
keep that
support of
available
Yeah.
for them. That's a good point. I can't find that table. Well, this is clearly an important issue, and I'm glad to know that we have both sides represented, because I think it's important to hear both of those, and I'm not sure we've settled that one yet. And I'm trying to find, Mr. McBroom, you probably can get to it faster than I can. The parking table that we've sent it to already, I think is very close to what you're proposing, but probably not exactly the same.
I
You
think
got it?
actually, what you're proposing might be a little bit more lenient than the parking table,
So,
but I just.
The parking table that I'm looking at here, let me get back to a single-family house in the UZO, is 1.5 spaces for a 2-bedroom or more. I'm scrolling to try to find it as fast as I can, but,
Right. Thank you.
single-family home, 2 spaces. 2-family home, 2 spaces per unit. Multifamily home in the UZO, a 2-bedroom or more, is 1.5 spaces. So it's essentially requiring a half more parking space for a 3 or a 4-bedroom unit, but it is also removing the reductions for being close to public transit or being on a sidewalk or something like that, which you get to reduce 10% for this and 10% for
Yeah.
that, and
Because you actually can get down, you can get from 4 spaces to 3 through all those reductions. Otherwise, it doesn't really,
you can
do
get
anything.
it down there, yeah.
that's very true. That's
Yeah,
very
I know
true.
we did an exercise on a development that I'm working on, and the current parking was 1.5, for the 2-bedroom or more. And the pending legislation brought it up to, 3 or 4 bedroom, so 3 or 4 parking spaces. And then with the credits, under that pending or not, the one that they're trying to pass, with the credits, it still left them with needing 2 or 3 parking spaces for a 2 or 3 or 4 bedroom. So what you're proposing would, like you said, only add half. So I don't know if that's the solution, but I do think it's worth discussing.
Gotcha.
And if there's only on-street parking, how is it measured?
On-street, you can count half of your parking with on-street parking. So if you need 3.5, which is really 4 spaces, then 2 of them can be on the street.
That would be in the reduction table that we would be looking to limit. That's sort of listed as the notes below the table, that we would be
And-
looking to limit for.
And I will say, back when this all started, before we had, the benefit of all the experience that we have now, one concern was just trying to ensure that houses that got built look like houses and not like not like hotels in the middle of neighborhoods. And the specter of having the whole front yard paved with parking was something that didn't seem like a good idea at the time. So, that's kind of where we landed, why we landed on the, let's just treat it like a house and see what happens. And so here we are, now we have data. And we clearly, have instances where it's a real problem. And again, in the areas where it's a real problem, it's where there's the least space available to provide it, it seems like. Deborah?
Yeah, I guess I just keep circling back to, I just don't know if it's going, I don't know if it solves the problem,
Doesn't solve it completely, no, but nothing will,
Yeah.
right? But it makes it better.
I just don't, I guess I keep going back to, if there's really no parking, let's say in Germantown, to be had, I just don't know if 2.whatever% of the complaints are parking.
Sure.
I mean,
No,
we,
look,
I
we
mean-
admit it's not a silver bullet, but nothing that we've discussed here is
Yeah.
a silver bullet to anything, we're just what can we do that's the best we can do, And this is.
Yeah. What's the
Yeah,
best we can do?
unfortunately, it's, with any good thing comes some issues. With any benefit, there's gonna be some drawbacks. I come from the hotel industry. People think because I'm enforcement that I'm just anti-STRP. That's the furthest thing from the truth. I live it every day. I see it from both sides. And I'll tell you right now that Nashville has benefited greatly, in the tourism industry due to the fact that we were severely underbuilt on hotel rooms, particularly hotel rooms of a certain level, grade, and this provided a very, very suitable way. Now, it snowballed very quickly, and some things got a little bit out of hand before we knew how to address them properly. Well, I think we've got a pretty good handle on it now, but with these benefits, you're going to have issues, and the problem is everybody wants to be as close to town and the action as they can be. So that's where the crunch comes in. Unfortunately, we have a large number of permits that have been there for a long time and they're grandfathered, and there's really not going to be a great deal that we can do about it going forward. They have the rules, they live under the rules, they're governed by the rules that were in effect at the time the permit was issued, and there's not much we can do about that.
But for new ones that are coming,
Yes,
we can
but,
try to be thoughtful.
and it's definitely worth it to look at that, especially for the closer to the center of town you are, the greater the scrutiny should be.
Gotcha. And you handed me, so my understanding is that the parking one has been through planning and was disapproved. Is that correct?
That is the latest information I had. I printed this last week.
Okay,
Last meeting.
last meeting.
I haven't checked for an update since then.
Gotcha. Because I didn't know what the planning had ruled on that one, so
It
that,
was unanimously disapproved.
it was unanimously disapproved. Okay, that's noteworthy. And it's already had its council public hearing, right? They've just deferred it to wait on this discussion.
To the 15th of March.
Ooh, this is coming up.
Yeah, that's,
It's our next council meeting. So, well, then I think we may, perhaps as a group, and I'm sorry we're missing, that we don't have more neighborhood folks, because I think we're having a good balanced discussion, and I appreciate that. That's probably the first one coming back. I think the others are waiting till July or something like that. And again, the goal is to help Mr. McBroom out and only have one set of rules that come through. So, Mr. Hargis, do you have any idea on when the water stuff might be ready? It's not gonna be ready to file tomorrow.
No, ma'am,
Okay.
it wouldn't be, no. I don't. I'll have to get with the director when he returns. next
Gotcha.
week.
Okay, so I mean, at best, we're not gonna have anything ready to file for the March 15, so we will ask for deferral on that for further discussion. So, and that brings us back to, this has been a good discussion. Like I say, I feel like we're close. I think that we can take what actually needs to be legislation and get that summed up into one bill and provide y'all with that. On the parking, we can maybe have that one as a separate one with your suggestions in there and throw that out there as well. And then on the, let's see, distance requirement, that's just gonna get generated. That will not be new language. And on the overlay, it sounds like this group is comfortable with trying to talk the sponsor into dropping that one and just allowing people to rezone. So that there wouldn't be any response from us. So what we're coming back with is just better documentation on the owner occupancy and the curtailing services. And then we haven't talked about, whether reducing the number of the occupants is the way to solve the problem. If there are only 8 tenants instead of 12, then you don't have so many cars. And that's probably a bigger discussion than for tonight. But I will say, of all the grumpy calls I've gotten, none of them have been about 2 people staying, or even 6 necessarily. It's the 20 that don't have any business being there, or sometimes the 12.
it seems like 10's the magic number. That's when the witching hour starts.
From there. Yeah, so that may be useful information. I think that's something that should be done thoughtfully. So I'm gonna let us go. Doggone it. We've done it again, but I think this has been good discussion. Do we, what I would like to do is provide y'all with kind of a summary of this, and let's officially go to whatever groups you represent and say this is legislatively, this is what we're close to doing. And then change to the website wise, this is what we have done or are close to doing. And then we've already, I think we've got the hanging feedback from the Germantown group on the numbers that you would like to see on the parking. So I've got other neighborhood groups that I'd love to get their input on the parking as well. Because as I said, I mean, that's a little bit of a two-way street because it's more asphalt or concrete in the neighborhood too. So I think that feels to me like the one that we still need to continue discussion on, so grab that. Do we come back in 2 weeks? Let's see. That will be immediately after the March 15th meeting. So at that point, I think we will know what happened to the parking bill on that one.
I'm going to be out of town. that
Okay.
week.
Do you want to, is there someone else from Germantown that,
Yeah, probably.
okay.
Sure.
Because, I mean, I think that sort of is where the parking discussion is centered, so I would love to have that viewpoint represented if we could. Or,
Did you say the 16th?
yeah, March 16th.
I will be out of town as well.
That's sort of spring break,
Same.
so maybe losing a lot of people. Do we need to look at 3 weeks? Does that get us back into the hearing?
We did have a short-term rental meeting 23rd.
Is the 23rd any better? Okay, sounds like it. All right, so good. That gives us enough time that maybe we can hit anybody that meets monthly will have been able to. Okay, so we're gonna meet again March 23rd. 23 here, same time, same place, 6 p.m. Okay, so the goals for the next meeting, I do think we're close. I would love for our goals for the next meeting is to have all legislation finalized and to have the website finalized, and to have input from neighborhoods on the things that we've talked about, and maybe the last thing to settle will be the parking solutions. And if anybody has a stroke of genius and something else, bring it up. Other questions or thoughts or comments? Great, thank you all so much. Have a good evening.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.